All right, Mr. Manning, who are you ready on, sir?
Mr. Lyons asked Steve to move for his bond motion. But I am ready to the others.
All right, court calls number CR 20-372, State versus Leonard Marshall Williams. And this is on the defendant's motion to suppress. Is that correct, Mr. Manning? That's correct. Is there any agreements between the parties regarding the motion to suppress?
Discussion statements. Express. First. I believe just for efficiency's sake, we agreed to just submit the video reports. Version of their times will take up action today, although we will have black witness to just record purposes. We have agreed to just enter the rest video purpose of this hearing. Judge, I wasn't aware to be publishing them today. I think I'm fine with that. For being safe. The Parsons session we have about stopping on video. And so fine for purposes of this hearing, those be published. And
Okay. You already have that, Mark?
I don't know. We can just call it. It's, I suppose, just kind of clear a little later.
State saying?
State saying.
No objection, correct, Mr. Manning?
For purposes of this hearing.
All right, court will admit State's Exhibit A, the body cam.
It's in-car cam. There's three, it copied 3 times. There's 3 in cars, but it's all the same thing. It just copied 3 times.
All right, court admits State's Exhibit A for purposes of this motion to suppress hearing, the in-car camera video. All right, with that, are you ready, Mr. Woodwhite?
Yes, sir. We call Officer Anthony Garza.
All right, Officer Garza, if you don't board, please. Okay. All right, Officer Garza, before you have a seat, I'm going to put you under oath. If you'll raise your right hand, sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? Yes, sir. Please have a seat. You can move that chair around, make yourself comfortable. I'm gonna adjust this mic. I'm just gonna pull this out. Comfortable with that. Speak up loudly and clearly during your testimony so we can all hear you.
Yes, sir.
Ensure that we speak one at a time. I have a very hard time of taking down 2 people are saying at the same time. Okay.
Yes, sir.
All right. Mr. Woodwhite, you ready, sir?
Yes, sir.
You may proceed.
Please state your name.
Anthony Garza. Currently, with the Van Police Department. Patrol.
March of 2019.
I was employed by the Edgewood Police Department.
And you were patrol officer at that point.
That's true.
On the night of March 21st, 2019, I guess it was early morning that day. Did you have occasion to come across the red Canadian car?
Yes, sir.
And what drew your attention?
The vehicle was traveling eastbound on Highway 80. I was traveling westbound. The vehicle had its high beams on. I flashed my high beams to get their attention to lower their high beams, in which they did not.
What did you do?
At that point, I turned around, got behind the vehicle, and then made a traffic stop on the vehicle for failure to dim headlights.
And that is a violation of prohibited by law of transportation section 547.333.
I believe so.
What did you do at that point?
I went up and made contact with the driver and got his information along with the passenger's information.
Driver was a Shelton.
Yes, sir.
And the defendant was Leonard Marshall Williams, is that correct?
Yes, sir.
Recognizing that,
Yes, sir.
indicate where he's at,
He's in the orange jumpsuit beside him.
seated at council table.
Yes, sir.
So you made contact with these two individuals, maybe one vehicle,
Yes, sir.
and what did you do once you gained their contact, their identified?
I went back to my patrol car and ran their information through our county dispatch.
Was the driver wanted?
Yes, sir. He was wanted.
He had multiple felony warrants for out of state.
Yes, sir.
They were heard upon and he was subsequently arrested.
Yes, sir.
Was Mr. Williams
No, sir.
and between the time that you get their communicate, you get their information, you speak with dispatch and you go through your process. Do you have any contact with the defendants with the driver of the vehicle?
Only when I initially made contact with him at first.
So after you got their information, you go back and basically until you discover one of them is wanted, you have any contact.
No, sir.
And so what do you do then?
I got the driver out and placed him into cuffs for his warrants.
When you make contact with these individuals at the beginning, did you notice anything that drew your suspicion about it?
There was an odor of marijuana coming from inside the vehicle.
And you arrest the driver, and he seems to be aware that he's no warrants, right?
Yes, sir. He was aware he had the warrants.
And truthfully, beginning, when you tell him why you pulled him over, he basically admits that he built in his license.
Yes, sir.
So that was yes.
Yes, sir.
So he was walking.
Yes, sir. He was very cooperative.
As you're arresting him, you ask him anything.
I asked him if there was anything inside the vehicle and if he minded if I searched the vehicle, since I did smell the odor of marijuana coming from the vehicle. His response is that he was just a driver, that the defendant was the owner of the vehicle.
He then made contact with the defendant, is that correct?
Yes, sir.
Does he admit anything?
When I get him out of the vehicle, he said there was a blunt in the back seat.
And so at that point, you asked the surgery, you just wait.
At that point, I went on and I pulled him out and had him sit behind the vehicle on the curb.
And you're gonna do your search based on his mission and their marijuana.
Yes, sir.
And what did, during your search, did you find anything?
During the search of the vehicle, only thing found inside the vehicle was the marijuana blunt.
Was there anything else discovered in the vicinity?
Once I turned around near the passenger side door in the grassy area, there was a tan bag that had been thrown out on top of the grass.
And that's the passengers where Steve Williams is sitting, right?
Yes, sir.
So right there in close proximity to the vehicle is a bag. And what do you do about this?
At that point, I go and I look and check the bag, and then I unzipped the bag. I found a Ziploc baggie full of white pills.
Do you know what this is?
At the current moment, no, I did not.
What did you do with that?
At that point, I went on and arrested the defendant, since they were in close proximity to his location, for the possession of the contraband that was located in his vicinity.
You read it right now.
Yes, sir.
You ask me questions.
I think I asked him if those were his, and he said to me no.
At that point, they're both under arrest. What do you do now?
At that point, I went on and I had to wait for a tow truck to take possession of the vehicle. Then I took both of them to the Van Zandt County Jail.
Mr. Man, you're with us. Mr. Bain, can you turn your microphone on? Yeah.
Officer Martin, my name is John Van Anderson, Mr. Glenn Williams. I see, looking through the reports, that you certified on May 19th, 2019, that you turned in everything you had, correct?
Yes, sir.
Have there been any supplements or updates in the case information since May 19th?
No, sir.
And there's nothing else in your possession or possession of Edward P. turned over to you?
No, sir.
When we talked about the stop, the state kind of lost on that one. And I slow that down for a second, look at specifics as to what happened, because that's obviously not a video. That part of the stop. Where were you positioned when you first noticed the red call?
I believe we were passing right in front of the high school, the Edgewood High School on Highway 80.
And where do you see on the stop?
Let's let that pass. All right, Mr. Bain.
Were you stationary? Were you
I was moving.
in which direction?
I was traveling westbound.
Which direction was the red vehicle?
It was traveling eastbound.
And approximately how far was the red call first?
Maybe quarter mile.
And when did you leave or first notice that you felt with the eyes?
I noticed they were on high setting. Once the vehicle got closer to me, I flashed my high beams.
Approximately what distance you flashed?
1,000 feet.
What led you to believe they were on the hot seat?
The light was overpowering. This you couldn't really see because it's blinding almost.
Were those the standard bulb, which is the big LED, right?
I believe they're a standard bulb.
And do you know what unit it was?
I would believe is early mid 2000s.
It did look like it had work that had been done on it, non-standard, non-back.
No, sir. It had a paper tag where they just bought it, apparently.
Is it common for dealerships to fix up things like tires, headlights, paint jobs, that kind of thing?
I guess normal maintenance, yes.
Did you check the aluminum requirement for those headlights and stops?
No, sir.
Did you check and see if the IV were actually activated?
I believe they were because he turned, when I acknowledged Mr. Hubbard, he turned them off.
And would that be shown on the video that shows the active stop?
I believe it should be.
That's correct, you didn't have a body camera. Correct?
I don't believe so.
If I were to say that as part of your case you turned in, you checked that you did not have a body cam, would that be an accurate statement?
I believe so.
Was Edgewood currently issuing body cams at that point in time?
We were in the process of getting the camera systems.
So would you believe that it would be safe to say that when you turned in your report, you did not have a body cam on?
Yes, sir.
So what you're telling the board is that your recollection is what it is from, I guess that's almost 4 years ago.
Yes, sir.
You're just calling anything that you saw or from is that correct?
Oh, in my statement, I did mention to, I told him about the high beams. He turned them off.
You said that that's in your report?
I believe so.
Do you have a copy of the report? Officer Garza, if you could look on page 3 of your report.
Mhm.
Could you point out which paragraph it states that Mr. Hubbard dimmed the lights?
Paragraph 1, we're here when I then went and made contact with the driver of the vehicle who had still not dimmed the headlights.
And does anywhere say that he did, in fact? dim the
No,
lights?
sir, it didn't say directly that he turned them off.
Does anywhere there say that he had the headlights on high? Sure, must be better at this point, 4 years later, we're at the time.
Can you repeat that?
Is your recollection of what happened that night be better at this point, 4 years later, or go back?
Probably back in 2019.
So if it says that you did not get confirmation that I need to come on by initially inspecting the vehicle, or you didn't get confirmation from the driver to recover, would there be any more things that usually be in office report?
I guess so.
But it's your recollection that Mr. Hubbard, the driver, did acknowledge in some way on your dash cam video about the headlights, is that correct?
I believe so.
In regards to the video, what was the last time that your vehicle received maintenance from Callaway? On the video unit in your car, the dash cam.
When the last time it was maintenance or for the video? We leave our vehicles there. I don't know. My days off, it could have been maintenance. I don't know.
Who does the maintenance for?
They had for the video, they have a watch guard tech come through.
And do they keep almost regular maintenance?
I believe they do. I'm not aware of how they do it because I'm not the supervisor position.
That's not too. Something that was said in state's directive. You said that when you located the bag of pills, where was it on the ground?
It was on top of the grass.
And what exactly was the container or object that
I believe it was a tan bag with a zipper.
do we have any photos of that bag?
Unless it's on the dash cam.
And do we have any, is that logged in?
It was logged into evidence in Edgewood PD.
Do you understand, would it still be in evidence at NPD?
As far as I'm aware, yes.
When you picked the brown bag up, what did you do?
When I picked it up, I unzipped to see what was inside.
And where did you find it? Where did you leave
I unzipped the bag and found a Ziploc bag that had a substantial amount of white pills.
it? I believe you said earlier that there was unknown substance, is that correct?
At the time, I did not know what that was.
But you said that you arrested him for contraband. What specifically were you arrested?
What was I arrested him for?
Yes,
The possession of the pills.
but you didn't know if those were Tylenol, Advils.
I was informed by Officer Long, who was there as backup, that those were hydrocodones.
What was the weather like there on the side of the road on March? Sorry, yes. In March 29th.
I believe it was clear out that night.
Was there any rain? Any other?
No, sir, it was not raining.
What was the condition of the bag?
It was dry.
Was there any damage in it, marks, any rips, torn?
No, sir,
damage?
nothing.
Did at any point in time you see Mr. Williams drop that bag?
I did not specifically see him drop the bag.
And you were the one that got Mr. Williams out of the vehicle, is that correct?
Yes, sir.
At no point in time did Mr. Williams exit the vehicle or roll down the window or anything prior to coming up to speak to the correct?
I believe the both windows were down already.
And upon review of your dash cam, did you see Mr. Williams or anyone else throw anything out of that passenger?
I don't recall ever rewatching the video.
Sorry.
I don't recall ever rewatching the video.
Okay, so you haven't reviewed your footage or this?
If I did, it's been since 2019. I don't recall.
What happened to the pills after you took them to your desk?
They were taken to Edgewood PD and put into given to the property officer.
Who's the property officer?
Be Eric, Robert Deering.
And after you turned it into the property officer, you said Robert Mary.
Yes,
Who did you go to next?
I don't know. From there, I don't have any contact with it.
So you said that you did not have any contact with it after you gave it to Officer Mary.
No, sir.
Are you familiar with the protocol for dropping items off on testing at DPS crime lab?
Yes,
And have you dropped off items from DPS crime lab in the past?
yes,
Did you submit the evidence in this case to the crime lab?
When I'm taking those up there, I'm not aware of what case it's for. He's already packaged it. And it's in a box.
Does Edgewood keep a GFS log?
I believe so.
And was that submitted as part of your reports?
I'm assuming the officer Deering did.
Also, there's a lot of assumptions going on. We understand it. Wood's facing 25 alone. We understand it, right?
Yes, sir.
And you understand that we're trying to make sure that the evidence that was gathered is properly handled, that it's properly tested, and meets the legal standards for submission.
Yes, sir.
Okay, so when we talk about typical, how much you work for Edgewood?
From 2017 to 2022.
So during the course of those 5 years, did you see procedures and policies for evidence logging and chain of custody logging as something through your car?
I was given the protocol when we got evidence, we took it into Officer Deering. He then put it into packaging, and then either who was available was to take it to the lab.
And when you would give it to Officer Darren, would you sign a log or anything that you gave to him?
Yes,
And when he gave you items to transfer to Tyler, did you sign it without?
yeah, I signed a log that usually had multiple items that went at one time.
So if it's, the reason I'm asking this is because earlier you said that after you gave it to Darren, you were done, is that correct?
Once it was packaged, I wasn't aware of what I was taking up there. I just was signed for multiple items that went to the DPS lab.
So if DPS Lab has your name as the person who bought and delivered the items, that's because you unknowingly were taking this particular case items to the DPS.
True, correct.
But you don't know that for sure one way or the other.
I don't know if I took this specific one or not.
And you don't know for sure if you saw anything that specifically indicates Mr. Williams had any connection to the 10 bag of pills was found with something like that.
You talk about on the video?
Yes. Or what's your recollection?
At this point in time, I don't recall whether or not it was in the video or not.
Do you recall seeing or observing anything that connects Mr. Williams to the 10 bag you found the site?
Nothing that was particular that just strictly put him as the one who had it, but it was within close proximity of his location.
But there's nothing that said Leonard Williams on the bag, is that correct?
No, sir.
There's nothing that says Leonard Williams with the pills, is that correct?
No, sir.
There wasn't anything pretty done, is that correct?
No, sir.
He didn't admit to use the pills for his, is that correct?
Correct.
As a matter of fact, do you recall his reaction to something he found and you charging him?
When he got out of the vehicle, he had multiple items in his hand and he was on the phone.
But you remember his reaction when you said you're placing him under arrest?
I know he was telling the people on the phone that they're trying to charge me with something.
And was it one of shock, incredulity, disbelief?
He seemed upset.
Did he ask you what you were charging him with?
I don't recall what he asked me on that.
And at any point in time, as he was getting out, you said he has items in his hand. Do you remember what he had in his hand?
I don't remember all the items. I remember he had the cell phone because it was on speakerphone.
But you never saw the brown bag in his possession of it.
Correct.
Jeremy, I just spoke for like mine. Inconsistencies. We would like to ask other states, a
The objection. Motion carried. Yep, laptop, right, laptop. There's two nations of mine up there. Comments. Okay, laptop.
you know what, Judge, I'll withdraw the test this matter. Parts of it, each of the district leads to the to count the way that those there at the jail or the shootings.
They were weighed at the police department.
And so you're testifying that you did not take items of evidence out and anywhere other than to take them into the end of the police department, it's not as evidence, correct?
They might have been weighed when I first initially took him to the sheriff's office, so I could have put it on my report of the weight.
Is that typical protocol to weigh, at somewhere other than where you're depositing?
Usually we do it on scene, but I don't think I had a scale with me.
And was there anybody else present when you took those out at the sidewalk?
I don't recall who was there.
Were you riding alone, or was there anybody else to do with you on that?
I don't recall. Sometimes I had a rider who was civilian rider.
There's no law enforcement.
Officer Long showed up as backup.
Right, but at the jail wasn't real.
Jail staff, but I don't know who was working.
Does anyone keep a law against civilian riders?
I believe they do.
Would it be customary if someone wanted to ride, they need some kind of paperwork to document they were riding if they.
Yes,
And who would the custodian record be for?
it'd either be Robert Deering or David Hammonds. I finished the academy in 2013.
About 10 years.
Yes, sir.
And truth, and at this point, you're on night shift, correct?
Yes, sir.
For last night,
Yes, sir. Yes, sir.
you're all day,
All day.
but you've been an officer for, at this point, 4 years ago, you've been an officer for about 6 years. In nights,
Yes, sir.
so. You have, based on all of your training and your experience, you have a good knowledge of what high beams.
Yes, sir.
And. Your testimony is that what you saw were high beams.
Yes, sir.
Getting to the bag. You said you didn't think it was on top, that indicates.
That it had been recently put there. It hadn't had time to settle into the grass to grow around it.
So within, theoretically, within a short period of time.
Yes, sir.
And. What you know about narcotics, people don't just leave narcotics, right?
No, sir.
So the likelihood that those narcotics would just happen to be there is pretty low, I agree.
It's very low.
And Mr. Manning spoke about the defendant's reaction. You've arrested a number of people here. Correct?
Oh, yes, sir.
And you've seen every reaction imaginable.
Yes, sir.
Let's go with states here that they have. Isn't it true though that if you've been in a contamination, there was no direct evidence tying its employees to that act, is that correct?
Other than the fact that they had just gotten there, hadn't been there that long.
And for all you know, it could have been miscovered, it could have been somebody else. There's nothing direct tying its employees to that act.
There was nothing that was written on the bag or anything to say that it was his. No.
That's not responsive. There was nothing to directly connect him to that act of position.
Other than a close proximity.
The objections to Officer Garza being excused. Take a second. Further witnesses or evidence, Mr. White. Mr. Manning.
Judge may have a question.
You may.
Yeah, Chris.
Mr. Manning, if any motion, you'd like to argue first? Yes.
There's we found motion to suppress, simply because as we beginning of this investigation, what we see is guesses, we see speculation, we see unanswered questions. Officer Garland testified, he did the high game fraud, he did check the account. Light bulbs, he checked to see the switch levers to activate diving lights. He did ask any of the occupants to confirm whether or not that vehicle was on or off at that point in time. He didn't ask any questions about the vehicle, nor did he allow anything that was showing make model, any type of information that helps understand whether or not the vehicle the whole reason for the stop. But just to judge, when establishing the nexus to this particular individual, there was nothing. There was simply a proximity to something outside the vehicle for which this officer decided that he was going to actually. And so for those reasons, we asked the person to stop and search based on that stop. Any evidence found after the stop be suppressed. Furthermore, we asked evidence seized on the side of the road be suppressed in violation of the defendant's constitution.
Thank you, Mr. Manning. Would you like to respond?
Briefly, Your Honor, Judge, I think the evidence, I mean, the testimony is clear, the evidence that's submitted. Clear that the officer had reasonable suspicion, pulled him over, failure to headlights. Based on his training experience, he can do that without having some sort of measurements of that. It's not required by the code. It's just they dim their high beams. She has said that they failed to do. As to the other arguments made by the defense, all that goes to weight and not admissibility. Those are all things that are questions of fact. The jury did not properly before this court. There is no allegation of wrongdoing or that there have been violations of his rights as far as anything beyond. They didn't have reasonable suspicion at the time. The fact that the drugs are found close, sure, there's no great evidence. That's a decision that jury can easily find beyond reasonable doubt. When that's
Just the reason there's both in 527 333 and in the definitions for 527 traffic code, it clearly defines what the offense of having a high beam zone, it defines specific distances, it defines specific lumen requirements for the headlights, taillights, and the officer had none of that information, gathered none of that information as part of the seizure, and so therefore we asked that this evidence, because of traffic stop, was illegal, we asked this.
Thank you, Mr. Manning. And I'm assuming the parties have watched the video, so upon the court reviewing this in chambers after this hearing, what's the video going to show with regards to whether there's high beam illumination or not, or any question about it?
if I may, Judge, that portion is not on video. It's the video turns on and the officer turns on his lights over, so that this approach is not. So it's gonna be the officers.
And additionally, there's no, from the defense's perspective, there's no noticeable difference in the lights as they're projecting from the defense vehicle. However, we will acknowledge once the officer pulls up and pulls on and take down lights, it is difficult to see any changes or variations that may happen. There's no, from the defense's perspective, what we showed today, there's no clear delineable difference between the lights as they're pulled over officers that were allegedly. And Judge, the driver is gotten out of the car at 27:30 on the video. And so prior to that, you can see the approach. The officer does initial investigation, go back, runs, there's a significant delay in time as he waits for the warrants. But at 27:30, he comes back up, and gets the driver out, still get time.
And recall Officer Garza's testimony was, when questioned about his report, that he did confront the driver about the reason for the stop being failure to dim. Is that going to be reflected on the video?
He mentions to the driver that the reason for the stop is failure to dim. And it's difficult to hear what the driver says, but it sounds to me as though he says, oh yeah, I forgot, or something of that nature. It's hard to tell, but it does seem like he understands or admits that, yeah, I can do it.
All right, and the court's going to take the arguments, under advisement. The court will review state's exhibit A as the parties have requested, and the court will issue a ruling on the defendant's motion to suppress. Before our next setting, and let's go ahead and set Mr. Williams.
Judge, my understanding is this was one rolling trial docket. He was number 8 as of June 5th. My belief was that he had a special setting prior to my being appointed as his attorney. He had a special setting in September, October, but I'm unable to locate that this morning.
I believe he did have a special setting, but I believe we removed that due to him requesting new counsel.
So he's going on their settings, especially.
I have him set, he's on the court's trial docket, just on as a special setting. I believe he's number 8 in the court's top 10. He was removed from special setting due to asking for the attorney. So we didn't want to sacrifice that day. We didn't know who his attorney would be, or if he would have an attorney at all.
I mean, it seems on the plan and see the coordinator and see if that all happens, but we could get Mr. Williams, I know Mr. Williams is doing custody, continuous custody, possible. And he would appreciate it.
And this court's been trying to accommodate Mr. Williams with that, but Mr. Williams has consistently asked for new attorneys. I believe you're his 3rd or 4th attorney, so.
And my understanding was that he had just required previous.
It's proven my point. He's had multiple attorneys, so I've had him said numerous times. He's asked for new attorneys, so the court has gone out of its way to give Mr. Williams today in court, so he will get that. But it would have come a lot sooner than today. Had I not had to deal with this request for new attorney. So to be that as it may, yes, you contact Mr. Abraham and ask for a special setting. Is there a need for a special setting for Mr. Williams? Understanding that he is in custody in those cases, will get priority according to law and his policy of this court. But from the state standpoint, request special setting based on witnesses, complexity of the case.
No, Your Honor, all the witnesses, local law officers, one is not being a chemist. However, our new policy is that we serve all witnesses. Some case of the trial docket, so I believe that the case, this case, that are served. Additionally, judge for the record, it's the state's position that this is a compliance of life case. Claims one was claims prior to we recently made an offer for the date of 25. That offer will expire 30 days after this.
Taking a straight.
And Judge, just by way of housekeeping, also in my motion file. Objections to the chain of custody affidavit, certificate of analysis affidavit. If I understand it, they're gonna have a witness here anyway, but I did see there was a certificate of analysis that was filed, and the defendant doesn't object to that.
Court does acknowledge that in reviewing the defendant's motion to suppress, that there's an objection to the certificate of analysis without a sponsor. So that's noted. So you can request that special setting, state review, discuss that with me. I'll make a decision on that. Since he is already on the court's trial docket and you're not requesting another hearing for the pronouncement of this, the court will just issue a ruling in writing. Are you ready on Mr. Lyons too, or do you need some time?
If I just have a moment, he requested to speak to you when he got.
Sure, that's fine. Are you Miss Bradley? Miss Bradley, come on up to these podiums over here. Just walk that way. Up to the podium. This is cause number CR 20-1, State versus China Bradley from the 9 o'clock morning docket. Right there, the podium, you're right there, where you're supposed to be. Miss Bradley. Court hearing was scheduled for 9 a.m. this morning. Why were you not here?
Oh, I got off of work at 5 and I really wasn't aware of it until this morning. My grandma let me know. We had our address was changed last year. We live in Quinlan now.
How did your grandmother know?
Cause I guess they said she got the mail, I guess like yesterday or something. I don't know.
She called you this morning? Just happened to call
But
you
when I got off, she let me know this morning when she woke me up.
that you had court today?
Mhm.
Why did y'all not have that conversation before today? Ms. Bradley, you are charged, you're on probation for possession of controlled substance, and you're on community supervision for that. And the state has filed a motion to adjudicate your guilt and to revoke your community supervision. You're aware of that, correct?
Yeah.
You were arrested on that and you were granted a person bond. And so, Ms. Bradley, how do you intend to resolve this motion? Are you going to hire an attorney to represent yourself, to represent you, or are you going to be asking the court to allow you to represent yourself? How do you plan to handle that?
I guess getting a friend.
I see that you've requested a court-appointed attorney, but based on the amount of money that you made versus the amount of expenses and obligations you owe, the court doesn't find you to be indigent at this time on all court-appointed attorney. So you have two options now. I can reset the case, give you 30 days to hire an attorney, or you can ask the court to represent yourself, which is not advisable, but still your right.
Yeah, I don't want to do that.
I think that's a smart move. So what I'm gonna do, Ms. Bradley, is I'm gonna reset you for another hearing on the motion to adjudicate. I'm gonna reset it to I'm gonna do Tuesday, June 27th. That'll be at 9 a.m. in this courtroom. So here, let me see that. Let me see. You write some things on there. Help her. All right, we're gonna bring this to you. You're gonna sign where it says defendant and we give you a copy of it. I would suggest that when you speak with the attorneys that you're gonna be talking with, that you give them the information that's on here so they make sure they can assist you properly. Ready to go. And Ms. Bradley, don't forget, you're on probation still, okay? Just because they file this motion doesn't mean that you don't report, that you don't pay, that you don't keep on doing everything that you're supposed to be doing, okay? If you stop doing all of those things, then the state can amend that motion. They can let all those things that you stop doing, okay? So it's in your best interest to keep on reporting to your probation officer despite that, okay? All right, you're free to go. For the record, Constable CR 20-1, the court previously this morning called China Brown. She was not present. Court issued a judgment not side alias capias. Court is going to withdraw that judgment not side based on her appearance today and setting her case for MTA on June 27th. So court will withdraw that.
Judge, I think I'm ready to do that.
All right, I show that we have a couple that are set for status, some that are set for arraignment, is that true?
Judge, you actually on production. But it looks like yes, we also have. Additional here for arraignment. I don't believe. Not preparation for the on production, I believe. Yeah, the indictments for. But if you like, we can set his cases for arraignment, as well as. Some. Fire effects.
Mr. Woodwide, would you assist the court, would you print out the indictments? For CR 23-2, and CR 23-14.
Printed out the indictment in. CR 23-14. Number for the court's record. Motion, I'll present the court here in just a moment, a motion to dismiss CR 23-02. That is a duplicate charge. The state and Mr. Lyons had an agreement, Mr. Lyons and Mr. Lyons had agreed to waive indictments. So I filed an information. Then he changed his mind on that, so we then took it to the grand jury, that was CR 23-014. So I will be submitting to the court a motion to dismiss CR 23-02 as the duplicate. That was the charge file like information that he's honest not going to waive indictment on it, as this is right. We just took it to the grand jury subsequently.
Okay.
And Judge, his name is spelled correctly, you understand the charge against at this time, please,
With regards to cause number CR 23-14, the court will find that Mr. Lyons has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record. We'll set that matter for pre-trial hearing just. And court finding that the state has made an oral motion to dismiss cause number CR 23-2 as a duplicate charge to CR 23-14. Court grants the state's motion.
Thank you, Carlos, for that.
Thanks. All right, so CR 22-276 is Bernadette Habitation. That would be your separate status on that case. What's the purpose of the status?
Judge, we were asked points that previously. And been around to have agreement. That agreement fell through, he was quickly filling trial dockets. And then on the trial dockets, on it out. And then we were just setting it for ourselves based off of that. He initially had a few charges. So I think that's why we had the status. I don't know if you see those charges.
It's my understanding, Mr. White was arrested on new charges. 4/28, 2023, Vietnam, which charges. So we're waiting to see what's happening with those, but my understanding is he's on a court's trial, that's completely may have failed to hear, that's why he's in custody. Statute, so jury selection, maybe we need to put it back on jury selection. Ongoing charges. I mean, I guess pending new charges. Jury selection is for. Permanent life.
Then Mr. Manning in CR 22-152 for the charge of unauthorized use of the vehicle. Is that the only case relevant to your motion to reduce bond?
Judge, we were going to request all our actions, all the cases listed. Only way to follow one of the execution of the CR 23-214. I believe he is currently on. Just I believe his bond is $490,000 for approximately. Approximately 10 cases. 15 cases.
All right, so you ready to argue your motion to reduce bond?
Judge, we are going to withdraw the motion this time. I believe we have reached a deal in the Strongman's case that's pending. Session.
We need to set this for status on. We need to go ahead and set this for jury trial and if there is a concrete deal that y'all can call up, coordinated with this Abraham for setting the plea or.
Judge, I still would believe we have the pre-trial on the new case. So we should set up pre-trial, other status, jury or whatever, that's fine.
All right, let's set CR 23-14 pre-trial hearing. Set that available on Thursday, July 6th. What about July 13th?
Judge, I believe I'm gonna be in trial. And call it. It's a 25 live circle. The 13th. If we may, we set it for 29th of June.
Set it for June 29th. That's evidentiary day, but I'm anticipating y'all may have an agreement with that. So we're gonna set all of us your clients' cases for June 29th.
It should be.
Okay, we'll see Mr. Lyons back on June 29th. And so, yes, you go, if you have it, you go ahead and take both the gentlemen back. Deputy McLeish. I'm ready for jail court, whenever jail court's ready for something.
Yes, Your Honor, I think we're ready for you as well, sir.
All right, I'll tell you what, I said I'm ready, hang on just a second. All right, Mr. Sanders, I apologize for that. All right, this is cause number CR 19-305, Sam versus Donald Brian Ellis. We're set for status on the DNA testing requested by the defense. It was reported to me, I think last week or week before last, that those results have come in from the Texas Department of Public Safety and have been distributed to both parties. Is that correct, Mr. Sanders?
That is correct, Judge.
All right. Any issues we need to take up about that report?
Judge, the only thing, we had that now, I hadn't had a chance to go over that with Mr. Ellis until today, so we've talked briefly about it. I would ask, I know in talking with the state, with Ms. Heisel, last week, I'd gotten an offer from the state that if Mr. Ellis chose to resolve the case with a plea, they had given us an offer. And Judge, I would ask if we could, I don't know if we could set it for either a plea or another status, maybe in 30 days to have some time to go over the results with him and answer whatever questions he has. And then if we reach an agreement, then to proceed with the plea, maybe in 30 days.
Any objection from the state?
Judge, at this point, the state has no incentive to enter it.
Just make sure that that's on, or he won't be able to hear.
This is on.
Yeah, just move it over there closer to hers. Can you hear okay, Mr. Sanders?
Yes, Judge.
Go ahead, Ms. Graham.
Your Honor, at this point, the state has no interest in entering into extending any plea offers to Mr. Ellis or entering into any agreement now that we've received the DNA results. They've had those since last week. There's no more time necessary. We're ready for trial.
Thank you, Ms. Graham. Did you hear that, Mr. Sanders?
Yes.
Okay.
So I'm taking it that the offer I'd gotten last week is withdrawn and that's no longer.
That's correct, Judge.
Okay.
Okay, and just for the record, can I hear what that offer was that was withdrawn?
It was 25 years TDC.
25 years TDC. Okay, so that had been extended to this by the state to Mr. Ellis, and Mr. Ellis had rejected that up until this point, but it's withdrawn, correct?
It hadn't been rejected by him because I didn't tell him about it until today. Because that's like I said, I hadn't had a chance to get over here to meet with him to go over the results and talk with him about that offer and the results of the lab test. So that's why I was asking for a little bit more time to discuss that with him.
But the state's position is firm.
It's firm, Judge. If he wants to tell us he accepts it right now because the DNA is a match, it's not 1 in 9 billion or 10 billion. It is a match again. If he wants to accept the offer Ms. Heisel made right now, that's fine. But once this hearing is excused, we have no reason to enter into a plea agreement with him and are not going to extend it on.
Considering that, Mr. Sanders, do you want to talk with your client and me recall the case here just a few moments so that you and he can make sure that you're on the same page before we make any further announcements?
Sure, Judge, that'd be fine.
I'll recall you in just a moment. Let me know when you're ready, Mr. Sanders.
Okay.
Mr. Schmidt, are you ready on any of your clients, sir?
Yes, sir.
Who would you like first?
Mr. John Horton.
All right, this is John David Horton, CR 21126 on status. Go ahead, Mr. Schmidt.
Judge, we're prepared to enter a plea on a lesser included offense for Mr. Horton.
Can you tell me what the terms are?
I can. This is CR 2100126. We're pleading to a lesser included terroristic threat against a peace officer. Under 1244A. 365 days in the county jail. He's got 365 days plus credit. 1245. CR 21127. 2021 00090. and DA 2021-0361. I believe that's satisfies the term.
Any court costs?
Yes, sir. Court costs $290, reimbursement $555. There's also restitution that's, being carried from a 1245 case of $2,274.54. That's from the criminal mischief case.
$2,074 and how many cents?
$2,274.54.
All right, Mr. Horton, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Mr. Horton, your name is John David Horton, is that correct?
Yes.
And Mr. Horton, are you a United States citizen who reads, writes, and speaks English?
Yes.
And have you ever been diagnosed with a mental condition? You have, correct, sir? And we've had discussions about that here in court. You've undergone examinations for competency. You've talked to the doctors. And today, do you feel like you have a rational understanding of what's going on? You understand everything that's going on here in court today?
Yeah.
And you've spoken with your attorney, Mr. Schmidt. You understand everything that he's explained to you regarding your case?
Yes, sir.
Is there anything that Mr. Schmidt's explained to you that you don't understand or you're confused about?
No, sir.
Are you pleased with Mr. Schmidt and the work that he's done for you? Are you pleased with Mr. Schmidt as your attorney?
Yeah.
All right. Mr. Schmidt, do you believe Mr. Horton to be competent?
Judge, a long-winded response to that question is Mr. Horton has had ongoing difficulties with competency and mental health. Post restoration, I've been able to meet with him several times. We've had intelligent, informed conversations about his case and the process. Spoke with him again today. And yes, I do believe he's competent and he understands the nature of the proceedings and the nature of the plea he's entering into.
Thank you, sir. All right, Mr. Horton, you heard what Mr. Schmidt read to me as your plea agreement. Is that right? You heard everything he said? Is that your understanding of the plea agreement and how you would resolve this case today?
Yes, sir.
You understand, Mr. Horton, if I approve your plea agreement today, that though you would be getting out of jail because you would have already served your entire sentence, you understand you would still be responsible for making payments towards your restitution. That's the money that you owe, court costs and reimbursement fees. You understand you would still be responsible for paying all those things.
Yes, sir.
And you understand that if you couldn't pay all those at one time, you could ask to be put on a payment plan with the court's compliance officer. You understand that?
Yes, sir.
Okay. Understanding all of that, Mr. Ward, do you still wish to go forward with your plea agreement today?
Yes, sir.
Okay. All right, Mr. Horton, you are charged by indictment with a first-degree felony offense of aggravated assault against a public servant. However, as announced, the plea agreement is to a lesser offense of terroristic threat of a police officer, which is is that a state jail, Mr. Schmidt?
Yes, sir.
That is a state jail felony, which if prosecuted under section 1244A of the Texas Penal Code would make the range of punishment for that offense the maximum 365 days in a county jail and a maximum fine, if imposed, of not more than $4,000. And I see here in your case that that is the proposition. So if I approve this today, Mr. Horton, you will be convicted as a felon, but you will have received a misdemeanor punishment sentence of time served. Okay. So understanding all of that, I would ask you to tell me at this time, Mr. Horton, are you guilty or not guilty of the offense of terroristic threat of a police officer?
Guilty.
Are you pleading guilty to that lesser crime because you are guilty of that crime?
Yes.
Has anyone threatened, forced, or pressured you, Mr. Horton, to plead guilty to
No,
this
sir.
or any other crime?
No, sir.
Okay. Court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the state's evidence?
No objection.
All right, state's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Is there anything further from the defense, Mr. Schmidt?
Nothing further, Judge.
Anything further from the state?
Yes, Your Honor, can I ask Mr. Schmidt if there is a waiver of in-person hearing in this plea package?
I'm sorry, could you restate that?
Yes, it's, Ms. Curry is wanting to, get confirmation regarding the plea packet and whether or not there's, a waiver of what'd you say, a waiver of in-person hearing. Is that included in your plea packet there?
Not that I recall, no.
We just emailed one to Miss Burns there at the jail. If Mr. Schmidt could review that with his client, please.
Did you hear that, Mr. Schmidt?
I did. Did you get that, Ms. Burns? Is that not written into the actual admonishments at this time?
It's not, I believe that the current case law requires the
Separate?
waiver on a plea.
Un momento.
Yes.
Stand down. So. This is basically saying that we're happy to be known to who instead of being taken. Understand? You did, okay. We've received it, so waived.
All right, thank you, Mr. Schmidt.
Yes.
All right, and Ms. Curry, I don't have the plea packet. Can you report, Mr. Woodward, give me the facts to support the plea?
Yes, Your Honor. On the date in question, the sheriff's office is called out because the defendant is holding a shovel in one and is called out for a disturbance. On arrival, the defendant is holding a shovel in one hand, a hammer in the other. Mr. Horton is clearly in the middle of a crisis and tells the officers, you're going to die today, bitch, to one of the female officers, and says many other things. Defendant is either says his wife got abducted by aliens, threatens the officers on scenes. They call for a canine. As they approach, they basically tackle him. He sort of swings at the canine officer, but I don't believe makes contact. He does state, "Don't make me hurt the dog," as this is going on.
Thank you, Mr. Woodward. Mr. Schmidt, did you hear that recitation?
I did, Judge, and I think with some caveats, I would mildly object to the state's recitation of the facts based on the video evidence. Mr. Horton wasn't in the middle of a crisis. He did have a shovel in his hand. He was very agitated. I know that he made verbal aggressive, I wouldn't call them threats directly at the officers, but at that point in time, they were quite a distance away from him, waiting to see if he would calm down. Ultimately, they did approach him, release the canine, and he went at that point without resistance. So he didn't threaten the dog. He was actually saying he didn't want to hurt the dog based on my viewing of the video. So ultimately the shovel and the refusal and the waving it around, I think legally constituted what we're pleading to on the lesser included terroristic threat to a peace officer.
And Judge, maybe I misspoke. I meant to say, please don't make me hurt the dog was his statement. He did not say he wanted to hurt the dog or anything like that. If that didn't come through the microphone.
All right, then based on the evidence submitted to the court finds that there is enough evidence to convict Mr. Horton of this lesser offense, terroristic threat of a police officer. The court will follow the plea agreement reached by the parties. The court hereby convicts John David Horton of the state jail felony lesser offense of terroristic threat of a police officer. The court will assess punishment under section 1244A of the Texas Penal Code at 365 days in the Maintain County Jail, or will award Mr. Horton 365 days credit for that sentence for time already served. Court will order him to pay $290 court costs, reimbursement fees of $555, and a restitution amount of $2,274.54. If those financial obligations are not paid at once upon being released, the court will order Mr. Horton to report to the Maintain County Courthouse and meet with the court compliance officer, Ms. Liz Harmon, regarding setting up a payment plan for those things. Furthermore, the court will dismiss under section 1245 those cases outlined in the plea agreement. Mr. Horton, you're hereby remanded to the custody of the Maintain County Sheriff so he can carry out the terms and conditions of the sentence. Mr. Horton, I'm gonna have you step over just a minute to be fingerprinted with Deputy McLeish. And Mr. Horton, once you get out of jail, as soon as you can, I want you to report up here to the courthouse and let's make arrangements to pay off the restitution, court costs, and reimbursement fees, okay?
Okay.
All right, step over with Deputy. Who's next, Mr. Mayor, or Mr. Schmidt?
Ryan Collier.
All right. Cause number CR 22-126 and 127, State versus Ryan Keith Collier. Sure that we're set for evidentiary hearing today.
We are, Judge. Previously, this was set on the 25th. As the court's aware, the judge was out of town that day. We do have a motion. However, we're not prepared to proceed today. We'd ask that that motion be reset for the next evidentiary. In addition to that, I have been in contact very recently with Ms. Curry, working on potential resolutions.
The objections from the state.
No, Your Honor.
All right, there being no objection to the board resets, Mr. Collier's both cases for evidentiary hearing on 6/29, it's June 29. Would be at 1:30. Who's next, Mr. Schmidt?
Covey, Michael.
Michael Shane Covey, CR 21-54, motion to revoke. Go ahead, sir.
That's correct, Judge. If the court will recall, Mr. Covey was PR'd and civilly committed to Northeast Texas. I believe there was some questions about the discharge paperwork from that facility. I think Ms. Taberham was trying to track it down. I'm not certain if I've received a copy of that or not. I honestly cannot recall. But I think that was the issue that we had at that point in time, was to try and determine whether or not Mr. Covey's bond should have been revoked, because he subsequently ended up at Terrell State, who requested a bench warrant. So if I could ask the court about that particular issue, as far as the motion's concerned, I think that the results of the mental health commitments will be material to the state's motion when we're ultimately ready to proceed on that one. So we'd ask for that to be reset.
Right. I'll tell you what, let me recall Mr. Covey, and then whenever we announce these other cases, I'll need to take a recess to consult with Ms. Taberham to find out what kind of information we have.
Yes, sir.
So Mr. Covey, go ahead and have a seat and I'll recall you just.
Richard. Judge, we're, oh, he's on.
All right, who do we have, Mr. Schmidt? I couldn't hear you.
Richard Bonin. We're sitting on a docket call, Judge. At this point in time, we'll announce ready to trial.
All right, this is cause number CR 22-353, State versus Richard Raymond Bonin. And just, okay, so can I go ahead and have for the record, what offer, if any, was extended and what's being rejected by the defendants?
I'd ask the state to lay that to the court.
Judge, I believe the state's last best offer was 7 TDCJ and a fine. Trying to pull it up, my computer is not. Do you believe the state's last best offer was 7 TDCJ, Josh?
All right, Mr. Schmidt, Mr. Woodwhite has indicated that he believes the last offer was 7 years confinement in Texas Department of Justice on a charge of first-degree aggravated assault, a dating, family, or household relationship with a weapon. And if that is your recollection of what Mr. Bonin is rejecting, the court will just note that for the record and will admonish Mr. Bonin that the court will not entertain plea agreements after today.
And Judge, I can tell you that my recollection is a bit fuzzy. It seemed to me, I recalled the last offer was 12 TDCJ. I know that me and Mr. Woodwike have met since then. I don't recall, but I don't think that it would change Mr. Bonin's response.
I don't hear Mr. Bonin objecting, saying he wants to talk about that. So, all right, the court will set this case for trial. We can begin setting this on the court's rolling jury trial docket beginning next week, June 5th.
You're supposed to be his next one. Yeah. Sure.
All right, this is cause number CR 21-208, State versus Bryce, Christopher Carroll, motion to adjudicate. Go ahead, Mr. Schmidt.
That's correct, Judge. I'd ask the court and the state to agree to an additional setting on Mr. Carroll's MTA.
Any objections from the state?
No, Your Honor.
All right, there being no objections, the court will set Mr. Carroll for hearing on the motion to adjudicate on June 29th.
Uh,
All right, Mr. Manning, you ready on Kristen Sipes?
Yes, Judge. Ms. Sipes just received an offer to resolve her case this afternoon. I was just speaking to her about that. And at this point in time, she's got a couple decisions to make. We'd asked for a little bit additional time to make those decisions on this motion to revoke. She's being housed in Henderson County. That's made it a little bit more difficult to communicate, but I think after a conversation today, we should have an idea of which direction she's wanting to head with that.
All right, any objection, state from setting this for final docket call on June 29th, which is motion. Well, I'm sorry, a final motion.
Final motion, no objections.
All right, court will set the Sipes then for motion to revoke on June 29th. That'll be the final set. She'll either accept or not accept. What's the word on that?
Yes, Judge.
Sorry.
Judge, I believe that concludes my business. May I be excused.
Yes, you may. Thank you, Mr. Manning. All right, this is Mr. Ellis. We're back on record CR 19305. Go ahead, Mr. Sanders.
Judge, as I said before, this was the first time I had a chance to talk to Mr. Ellis about the results and to extend the offer that had been made to me last week. And he understands the state didn't have to even extend an offer and they can withdraw the offer at any point. At this point, we're not ready to proceed to enter any kind of plea bargain agreement today. I think we have an October 2nd, I think is the trial date.
All right, court will. Do you need any hearings at this point that you're aware of, Mr. Sanders, on the results of the YSTR testing report?
No, Your Honor, I don't believe so.
Okay, all right, then the court will maintain this for special setting on October 2nd. Trial. And if an issue comes up between now and then, just notify the court and say, we'll try to get a hearing in advance of that day. If there are any pretrial issues that arise.
Okay. Thank you, Judge.
You're welcome. Thank you. Deputy McLeish.
Yes, Your Honor.
Since there's no one in front of the camera, I'm gonna stand in recess for a few minutes where I can speak with Ms. Taperham about the Michael Covey issue I was talking with Mr. Schmidt about. So I'm gonna take this break in action this time.
Yes, sir. Thank you.
All right, Mr. Schmidt, you ready?
I am Alicia Joyner.
Ms. Joyner, this is cause number CR 20-127, motion to revoke. Go ahead, Mr. Schmidt.
Judge, I'm gonna ask for a reset on Ms. Joyner. Came to visit with her the week before last, and they've had her in Henderson County. So I have not had an opportunity to discuss the motion with her. Ask for that June 29th date.
Any objection to the statement?
No, Judge.
Court sets Ms. Joyner for a final hearing on a motion for a vote June 29th. Mr. Joseph Cronin.
Yes, sir.
This is cause number CR 22-322. And actually, we're set for final docket call today.
We are, Judge. I'll remind the court, we were in here, I believe about 2 weeks ago, we were set to plead based on some information I received. I would not allow Mr. Cronin to proceed. However, we've been able to resolve that. And we'd asked that he be set for Thursday for a plea.
All right, court will set Mr. Cronin for plea. Thursday afternoon at 1:30. That's June 1st. All right, this is cause number CR 21-125, State versus Matthew Tom Hogg. Motion for vote. Go ahead, Mr. Schmidt.
Judge, similar announcement of trying to negotiate a little more with the DA's office on Mr. Hogg. We're not ready to proceed on a contested, but ask that it be reset for that June 29th date.
Any objection to the statement? All right, court will set Mr. Hogg for a final motion to revoke hearing on June 29th. Who is this, Mr. Schmidt?
This is Jeremy Hester.
This is cause number CR 21-291 for docket call. Go ahead.
Correct. We are set on a docket call, Judge. Mr. Hester has brought some things to my attention that I need to speak with Ms. Curry about as soon as possible. Hopefully, it will change the trajectory of Mr. Hester's case. We'd ask for a final docket call on his deal.
All right, court will set Mr. Hester for a final docket call on June 27th.
Roseman Shannon.
CR 20-363, motion to revoke, go ahead, Mr. Shannon.
As we'd asked for an additional setting on Mr. Shannon, not quite ready to proceed on contested.
Any objection from the state? All right, court says Mr. Shannon for a final hearing on this motion to revoke. All right, this is Gerald Wayne Powell, CR 21-235, status, the good news on Dr. Proctor.
Yes. Sir. So shortly after our last hearing, I emailed Dr. Proctor. He responded, "It is top of my list. I'm really sorry it has taken so long. It has taken longer than usual for a lot of reasons," and he lists those reasons, including the complexity of the case itself. I know Mr. Schmidt had tried to get some documents for Dr. Proctor. Dr. Proctor was waiting on those. As it turns out, Mr. Schmidt couldn't get them. But one thing I was not aware of, Judge, is that Dr. Proctor's partner, Dr. Price, passed away a couple months ago. I was unaware of that. So in addition to taking on additional cases, he became the one that was the managing partner of the practice. But he says, bottom line is, he said, "I plan to have it wrapped up by the end of the month." This was on May 18th, 1st of June at the latest. Thanks for your patience. So tomorrow's the end of the month and the next day is the 1st of June. So I'm hoping to have it sometime this week, possibly next week.
All right, so if I set it out 30 to 45 days, we should have that.
Yes, sir.
Any concerns, Mr. Schmidt?
No, Judge, that sounds fine. Yes.
All right, let's, today being the set it for that June 27th date. 1:30.
No. Mhm. Sounds good.
Your Honor, I think Mr. Schmidt only has one client. No, I'm disregarding.
Sorry. You want, I know you did.
This Mr. Torres.
Yes, sir, it is Mr. Torres.
This is cause number CR 22-196, State versus Ruben Camarino Torres for arraignment. Have you had a chance to go over the indictment with your client, Mr. Schmidt?
Mr. Torres understands what he's charged with, his name spelled correctly. We'll waive that upon reading, enter a plea of not guilty on his behalf and ask it to be set for pre-trial.
All right, court enters Mr. Torres' plea of not guilty into the record, finds that he waives the formal requirements of arraignment. Court sets this matter for pre-trial hearing. Is 30 days sufficient? Is that June 27th sufficient, or do you need more time, Mr. Schmidt?
What are my options, Judge?
July 11th.
July 11th should be fine, Judge.
All right, court sets Mr. Torres pre-trial July 11th at 1:30. Mr. Torres, if you make bail at any time during this case, all of your hearings will be shifted to 9 a.m. of the same day, okay, at the courthouse.
Do you know much of it? Yeah. What is it? I couldn't get you just. I get you. Want to sign this because I've never talked. Can we recall his case, Judge?
Sure.
Sorry.
Your Honor, I think it's now accurate to say that Mr. Schmidt is probably at a pausing point.
All right, bring Mr. Booker up.
Mr. Booker, come on up, sir.
All right, this is cause number CR 22-239, State versus Jimmy Saul Booker. Mr. Booker, you're aware, I believe, that the state has filed a motion to revoke your community supervision.
Yes.
As you represented yourself prior to being placed on community supervision, I need to know at this time regarding your motion to revoke, do you intend to represent yourself again? Or would you like the court to consider appointing you an attorney?
I'm gonna just represent myself, Your Honor.
Okay, and so, Mr. Booker, I believe that this court has already gone over all of the Faretta warnings regarding the waiver of court-appointed counsel. I don't believe that anything has changed from that time till now. So let me just ask you to make sure that you understand fully the potential consequences of your waiving of counsel. You understand, Mr. Booker, that you are currently charged with failure to comply with sex offender duty to register.
Yes, sir.
One second. All right, Mr. Booker, you are on probation from the sentence imposed on February 23rd of this year, wherein you pled guilty to the second-degree felony offense of failure to comply with sex offender duty to register for life. The court on that day assessed your sentence at 10 years confinement in the Texas Department of Criminal Justice, but suspended that sentence and placed you on probation for a period of 5 years. Also assessed a $1,500 fine. So the range of punishment, the maximum that you could receive in this case is 10 years in prison. You understand that, Mr. Booker?
Yes, Your Honor. But the initial agreement was 5 years probation.
I understand, but you understand the sentence that was assessed to you that day was 10 years in prison. That sentence was suspended and you were placed on 5 years community supervision. You understand the sentence, not the same period of community supervision, correct?
Right.
Now, have you had an opportunity to review the motion to revoke that was filed in your case?
Yes, Your Honor.
Okay. And so in reviewing that, you have seen where the state has alleged 4 separate counts of allegations. Is that correct?
Right.
And you understand if you represent yourself, Mr. Booker, then it'll be your responsibility to defend yourself against the state's attorneys with regards to each one of those counts using the rules of evidence and the rules of evidence. You understand that?
Yes, Your Honor.
You understand that you're definitely at a disadvantage because you are not a licensed attorney, educated in the rules of evidence or the rules of criminal procedure. You understand that?
Yes, Your Honor, but I'm pretty familiar with it.
I understand, but you understand you're still at a disadvantage.
I'd still rather represent myself.
I understand that, but you understand, you need to answer my question. You understand that by representing yourself, you're at a disadvantage.
Yes, I understand that.
And understanding that, you accept that risk and ask this court to allow you to
See, you broke
waive
that.
your right to counsel and represent yourself, correct?
Yes, Your Honor.
All right, and I believe that Deputy McLeish has provided you with a copy of the paperwork very similar to the one that you signed before, called for rental warnings. Have you read over that document?
Yes, Your Honor.
All right, you understand everything that you've read?
Your Honor, I just provided him with that document, so.
Well, he's read it before, but go ahead and read it again.
Yes, I read.
Go ahead and take a moment. Read through that. It'll be the identical to the document that you signed before you were placed on probation. Take your time. Read it.
Okay.
The 30th, yes.
Now, Mr. Booker, a couple of other things that I want to talk about. You've read over that document, correct?
Yes, Your Honor.
You understand everything that was written down? You understand everything that was written in that document?
Yes, Your Honor.
And you understand, Mr. Booker, that a motion to revoke hearing is not the same as a trial on guilt. You understand that?
Yes, sure.
You understand that the issue of what you were placed on community supervision for is not an issue. You already pled guilty to that. The court's accepted that. The court's found you guilty. The court has already assessed your punishment. The only thing at issue here are those allegations contained in the state's motion to revoke. You understand? That's what the
Yes.
state will be offering evidence on and trying to prove to the court that those things happened. And if they do so, you understand that their burden is lower than guilt beyond a reasonable doubt. You understand that? It's a lower burden.
Yes, sir. I think I have evidence to present to the court contrary to
Okay.
that illegality of the arrest.
Well, there'll be time for that, but before we get there, I want to make sure that you understand that their burden is not proof beyond a reasonable doubt. Their burden is a preponderance of the evidence.
Right.
Much lower burden. That means all they can do is have a little bit more evidence than you. You understand that?
Basically, my opinion is that there's just allegations that's raised in the state's motion, where I have evidence contrary to.
I understand, and you are correct, but what I'm trying to indicate to you is that the legal burden of proof is much lower in a probation revocation case.
Yes, John, I'm familiar with it.
Okay. All right. So understanding all of those things, you've read the Pareto warnings and you're asking the court to allow you to represent yourself on the state's motion to revoke.
I have a question for the court. Are those burdens based upon civil proceedings?
It's based on the code of criminal
Upon
procedure.
the evidence standard?
It is based on the code of criminal procedure. And the case law that affects them. Okay, any other questions about that?
No, sir.
Okay, and so you're asking the court to allow you to waive your right to counsel. You understand that this court could appoint you an attorney to represent you based on your indigence. You understand that, and you're waiving that today, is that correct?
That's true.
Okay, all right, then, I don't think I swore you in, Mr. Booker. Let me have you raise your right hand. Your other hand. Mr. Booker, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Now, Mr. Booker, if we went back and we had, you can lower your hand. If we went back and had, you can lower your hand. If we went back and had our whole conversation, you can lower your hand. Lower your hand, Mr. Booker. If we had that whole, Mr. Booker, something funny? Is this funny to you?
No, so I'm listening.
No, you're listening now, but you weren't listening a minute ago. I see you looking over and smiling and laughing. If this isn't serious to you, I'll just put you back in the cell and I'll call you up another 30, 60 days and we'll have this conversation when you're ready to be serious. Is that what you want, sir?
I'm not laughing, it's probably just the way I move my mouth. So, look, I don't see anything funny about it because I feel as though that I shouldn't have been arrested down here. But the allegation in the state's motion now is what I intend to challenge.
Well, then why don't you keep your eyes on me and your ears on me, quit looking left and right and smiling and goofing around? Why don't you do that? If you want me to do what you want me to do and let you represent yourself, then you gotta listen and pay attention. If I think you're not taking this serious, that's one of these things that's in this paperwork right here. And right now, I don't think you're taking it serious. So what I'm gonna do, Mr. Booker, is I'm gonna deny your request to represent yourself. I'm gonna deny it.
I'm gonna object to that, Your Honor,
You can
because
object all you
this
want.
court has already found me competent to represent myself.
And
I
I'm
believe the wolf is interfering with my representation.
gonna withdraw that finding, Mr. Booker.
Okay,
You can object all you want and I can deny it all I want.
so this was wrong. This was the purpose of the hearing was for.
Well, the purpose of the hearing today. what you-
I can't see nothing I've done.
Mr. Booker, today is not a hearing on your motion to revoke.
I
Today,
understand that.
I don't think you do understand that. You're too busy talking and you're not listening.
What are
think
you
that- I think that's-
supposed to be listening to besides you badgering me?
Me badgering you. Is that
No,
what you said?
what are you saying that I'm supposed to be listening to besides you criticizing my representation?
Me criticizing your representation?
Basically, I'm sitting here on humble and listening, making sure I'm listening to you so I can respond properly to whatever you're trying to tell me. I understand fully where I'm at in this proceeding. And it's like we're making a molehill out of a mountain out of it. What is it I'm supposed to do besides listen? When you tell me what I'm doing, I'm responding. Yes, sir, I understand.
That's the problem, Mr. Booker. I don't think you're fully listening. I think you're laughing. I think you're looking around in the room over there when I'm talking to you and you're
Is
not,
that not the meaning that's showing up on the camera?
sir.
Is that the same demeanor I'm seeing myself on now that I'm laughing? My demeanor is not showing that on the camera.
Not right now, it's not because I have your attention. A moment ago, I don't believe I had your attention.
Okay, Your Honor, if it'll help, please go. I am willing to be in full cooperation in listening to the court and answering the questions of the court.
I'm not fully convinced of that, Mr. Booker. I think you may be your own worst enemy here. But I'll tell you what, you can have a seat and I'm gonna think about it. And I think you should do the same. Have a seat. I'll call you back up.
This court takes judicial notice that
Mr. Booker,
I did attempt to represent myself.
would you like to sit back up?
Mr. Smith, who are you ready on?
Judge, I'd asked the court to recall Mr. Torres. That's unnecessary. We have, he was a little bit confused, but we had waived, formal reading of the indictment. He signed his reset notice for that pretrial date. And I'm ready on.
Stop it. Step up.
You can't make me look like I'm in here being disruptive.
I'm ready on Lisa trial.
No, I'm not being disruptive. That's the game he wanted to play when I come in here. Because last time I represented myself, I got to dismiss it. You can't put me in a position to get a work and keep over. Like that, man.
All right, Mr. Schmidt, let's try this again. What I heard you say was something about Mr. Torres.
That's correct. We don't need to recall him. He's been reset to that June 11 pretrial date. I'm ready on this, Lisa Trump.
All right, Lisa Renee Trout, CR 22-255.
Set for arraignment, Judge.
Yes, sir, it is. Go ahead.
And Judge, we waived formal reading. Her name is spelled correctly. She understands her charge. In her plea of not guilty, asked for a pretrial date on that June 11th or July 11th date.
All right, court finds that Ms. Trout's waived the formal requirements of arraignment. Will enter her plea of not guilty into the record, sets this matter for pretrial hearing on July 11th. At 1:30, Ms. Trout, if you make bail in your case, then your hearings will be at 9 a.m. on the ordinance. All right, this is cause number CR 22-94, State versus Taylor Leon Davidson for plea. Mr. Davidson, if you'll raise your right hand, I'll place you on oath.
Judge, if I may interject, we were set for a plea. However, the state's offer of 10 TDC, he would formally reject that offer and ask to be set for trial.
Somebody's going to fill me in on that. I thought we set this for a plea, that this was a done deal. No?
Well, it was, Judge. Obviously, an individual retains their right to change their mind. We were hopeful that we were ready to proceed. However, after a lot of conversations with Mr. Davidson and some of his family members, he's decided that he's best served exercising his right to a jury trial.
All right, so Mr. Davidson is rejecting what I presume to be the state's best offer. Yes, sir.
Yes, Judge, this is indicted as a 25 to life, and the offer was 10.
All right, so Mr. Schmidt, your client is aware of what the potential legal consequences could be as far as sentencing, should he be found guilty of this offense. As Curry has indicated that it's indicted that if the priors are proven to be true, that he could be looking at up to 25 to life. I'm in the Texas Department of Criminal Justice.
Yes, sir.
He understands that by rejecting the 10-year offer today, that the court is not going to entertain the bargaining after today. Meaning, once he changes his mind and rejects it, walks away today, there will be no 10, there will be no offers that will be accepted by the court.
I understand, Judge, and I've explained to Mr. Davidson his rights and his risks in detail multiple times. So yes, sir, he's aware of it.
Okay. All right, the court will set Mr. Davidson then for jury selection beginning Monday, June 5th. Mr. Davidson, you'll need to report to the Van Zandt County Courthouse on June 5th. Mr. Schmidt will not be required to be there on your case because you will not be in the top 10 yet. You will appear, meet with court staff on the second floor. Once you check in, you will also need to check in with your pretrial police officer if directed to do so, or you're going to meet with him whenever he tells you when and where to meet. And then you're going to continue to do that until your case is reached for trial.
Yes, sir. Did you have this on? No, we didn't. He's good. Okay. We're waiting to finish him up. He's good. So that's just Mr. Covey left. Okay. Weird.
All right. And Mr. Schmidt, let's recall Mr. Covey, Michael Shane Covey, CR 21-5. All right, court's gonna reset Mr. Covey for final hearing on his motion to revoke on June 29th. And the court has signed order reinstating his personal recognizance bond. And I'll have that file and a copy sent to you, Mr. Smith, along with a copy of Mr. Covey's medical records.
Thank you, Judge.
I'll send that do you want me to send that to the state as well?
Yes, please.
Or we'll send medical records to both Mr. Schmidt and Ms. Make sure the state gets it. Hey, Deputy, please, can you step out and call me? You get a moment. We'll take a
Yes,
recess.
sir.
Take a recess, right?
Okay.
Deputy McLeish.
Yes, Your Honor.
Let's see, we have Mr. Copeland, correct?
Yes, sir.
All right, Mr. Copeland, come on up. All right, this is cause number CR 23-93, State versus Rusty Wayne Copeland. Mr. Copeland, you're charged with engaging in organized criminal activity, a second-degree felony that carries a range of punishment of not less than 2 years or more than 10 years, I'm sorry, not less than 2 years or more than 20 years in prison and a fine not more than $10,000. I've already found you to be indigent in your other cases of aggravated assault, deadly weapon. And I understand at this time, that's not changed. Is that correct? You'd be requesting an appointed attorney.
Yes,
Mr. Adams has, he's no longer on the court's appointment list. So he is your attorney on those other cases, and he will remain on those cases until either those cases are resolved or he asks to be removed. So he's still your attorney on those other cases, but this is a newer case. And so the court's going to have to appoint you a different attorney. So I really just wanted to explain that to you, that you're going to have an attorney on the previous assault cases and a different attorney on this case. Okay.
Okay.
All right. And so we'll be sending paperwork over once we make the appointment. We'll send some paperwork over that will have the attorney's name and number on there, and you can give them a call. They'll make time to come see you. Okay.
okay, thank you, Judge.
You're welcome. So what I'm going to do is I'm going to reset you for another arraignment date. Set you for arraignment on June 15th. And we'll have the attorney with you on that day, okay? If there's a chance they may come see you before that, and it's not to have that hearing, but if not, we'll see you back on June.
Okay, thank you, Judge.
All right. And Deputy McLeish, on Mr. Booker, we're just going to reset Mr. Booker to June 29th.
Yes, sir.
There's no need to bring him back up.
Yes, sir. We'll get him a copy of the reset form.
The court is going to appoint an attorney to represent Mr. Booker over his objection. It is, and not sure we'll be ready on that day, you know, whoever gets appointed, but that'll be our placeholder. And let's see. Last time I got it, let's see, there's a Kenneth Phelan and Mr. Nolan Wyatt has filed a waiver of arraignment, and that's been approved or will be approved. Pre-trial is set July 13th. Deputy McLeish, is there anyone else that I've overlooked?
I don't believe so, Your Honor. I think our dockets both reflect the fact that we're done with the jail.
Great. All right. Well, thank you for your help with that. We appreciate it. If there's nothing else, then we are adjourned.
Thank you, sir.